Counsel, any position on the juror, Mr. Hayward?
Your Honor, he detailed multiple numerous negative interactions with the victim. Obviously, if I'd had that information during jury selection, I would have requested he be excused for cause for knowing the victim. And if the court had declined that, I would have used, one of my other pre-entries. I did not use all my pre-entries, not knowing that. So I would request that he be called as one of the alternate and excused.
Thank you, Ms. Michak.
He indicated that this was 10 years ago, didn't recognize her by name, voice, yes, but he also indicated multiple times that he would not use that prior experience with her as far as his deliberations would go. And that I would ask that he remain as is.
Okay. Okay, thank you. Well, there's a reason I pick 2 extra jurors, because sometimes things like this come up where they don't know people's names, but then they see them on the stand and realize, oh, I have this recollection of this person. And I do think in the exercise of my discretion that it would be appropriate to excuse this juror. I'm finding good cause to excuse this juror in light of his negative interactions. I would assume the defense would have the same position if it were Ms. Howard, who he knew and was saying he had negative interactions with her. The defense would be wanting to excuse him then. So I think it's fair and appropriate to excuse this juror as an alternate, and we'll do that now. We'll have 13 remaining. Okay, so you can let him know he can go. Thank you. Anything else, counsel, before we bring in the jury?
We do intend to call another witness.
Okay, thank you. And then we'll probably, unless Joe, he doesn't have the, okay, well, once you've both rested, we'll take a short break, and I'll put on the record the instructions I intend to provide, and you can place any objections you may have. Okay, thank you. Welcome back, jury. And I just wanted to note that I have excused one of the jurors. Please pay no attention to that. It must not impact your deliberations or verdict in any way. Okay, thank you. Okay, Ms. Michak, any other witnesses?
No.
No, okay. Any rebuttal witnesses?
Yes, Your Honor, we would recall Tristan Null.
Okay. If you raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please have a seat.
Thank you, Tristan.
Thank you. Ms. Jip?
I know we had an opportunity to speak yesterday. I'm just hoping to get some clarification. I'm just going to show you these pictures. Previously admitted as People's Exhibit, let's say 7. Do you recognize what's in these photographs?
Yes, that is Tabby's car.
Okay. Do you typically see her driving this vehicle?
Yes, all the time.
Okay. And let me ask you, have you ever seen her drive it? I'm going to just point. Do you ever see her drive it down this drive?
Yes.
Okay. If you could just give a guesstimate as to the regularity.
When her vehicle, I saw about 90% of the time go down that drive, whether it be her driving or Dave Beatty.
Okay. At any point, have you tried to kind of block off that drive so that they don't rip down there?
Yes, I was at the time putting up a glass table and some of the kids' toys that would be laying around the yard, just to kind of make a line of objects to block it off.
Okay, and did they acknowledge and decline to go down that drive? I should say, did Tabitha acknowledge and kind of back around and go another route?
No, they would, Dave would get out of the car and move the stuff, to points to where the kids' stuff would go back in the yard, and the table that would block it would get moved further and further in the back of the property to where we couldn't put it up no more.
Okay. We've kind of heard a little bit of testimony about the condition of the road. If, say, a vehicle was to be a lower profile, like a sedan, like Chevy Malibu, would there be any issues with it going down that driveway?
No, there wouldn't be no physical damage to the car, nothing that would put any damage towards the car at all. There's, I mean, it gets kind of bumpy towards the end when you go back down the hill, but other than that, it's a pretty decent way for people to get to the back.
Okay. And I believe you testified yesterday that there's 4 routes to the area where Dave's trailer was.
Yes.
Could you just kind of describe or kind of point out on the map where those other routes would go?
So on the side of my house, there's one. There was one that used to be available on the side of the block house where Roxanne lives.
Okay.
And then if you go down the driveway where my mom lives, back towards Dave's parents' house, there is one that is at an angle that sits across from my mom's house. And then if you go further down, closer to Dave's mom's house, there's a spot where you drive down a hill back there.
Okay, so really 3 routes, because 2 of the routes you have to use the driveway that your parents used.
Correct.
Okay. And if I'm to understand you correctly, this is Roxanne's house, the second house, the closest to the red bubble?
Correct.
And so there used to be a pathway back there?
Yes.
Okay. When you were outside on the evening of September 9th, did you witness your mom pick up any rocks and throw them at Tabitha's car?
No. Our driveway is a dirt driveway, but I wouldn't say you could easily pick up a pile of rocks out of the driveway. It would be like a search and find kind of thing, maybe a rock, maybe a couple.
Okay. And I'm sorry, we just heard a lot of testimony about different events. So did you watch your mom and Matt go back towards their house?
Yes, me and Josh stayed out there because we didn't want anything further to happen. I mean, who would walk away when there's 2 parties that dislike each other still out there? So we stayed out there, and I watched my mom and Matt walk down where I couldn't see them anymore. We still were outside for maybe a minute or 2 while Dave and Tabby were still on the property up front.
Okay, and in your memory, Dave or Tabby, who left, or was it a simultaneous thing? What happened there?
When everyone parted their ways, Dave went, because his car was facing towards the house, he went around and on the side, and then Tabby backed up and left.
Okay. At the time, did you think it's strange that she backed out?
A little bit, because usually she would follow behind Dave. If he was driving his Jeep and she was driving her car, it would be a follow.
At that time, did you know whether or not Tabby had her own cell phone?
I'm not sure.
Okay. Thank you, Tristan. I don't have any other questions.
Any questions, Ms. Mecha?
Is the trail to, I guess, by your house that Dave would have taken, covered in trash?
No, there is trash. If you drive to the back, there is a burn pile that sits behind the shed behind our house. I wouldn't say that the path that leads back there is completely covered in trash. Maybe a little flyaway of trash from the burn pile, yeah.
Okay. So all those specks of things on that picture, what would that be? Just debris?
So the building that sits behind my house, the building that you see the best behind my house, on the side, yeah, I wouldn't say that it's just trash that people go back there and dump on the whole pathway, because that was a drive for people to go to the back. So it never got really covered in trash or objects that would make it to where it was unusable.
And you're saying that a white car would drive down that path?
Yes.
You don't know who drove that in the car?
No, almost every time I've seen that car pull into the driveway, I knew who drove it, whether it be Dave or Tabby driving the car. I was always at the window watching it happen, everything, the moving, the objects, the driving down there, because I would always complain about it to my boyfriend for him to go and say something.
To then trigger an event?
No.
Or to have a conversation?
To have a conversation. I mean, my boyfriend and Dave, they don't usually argue. They actually really never argue unless it's something serious. Other than that, it's usually just a conversation that is had between them.
If you were to go to, I don't know what relation it would be, your grandparents' house, located in the back, which way would you take?
I would drive down the driveway where my mom and Matt live.
So you would take that drive, the driveway, the paved asphalt one?
Yes,
Why?
because, I mean, to get to Dave's mom's or to go out back,
To go to Dave's mom's house?
I would take the drive. I wouldn't see any sense of me going all the way around my house, all the way down a hill to go out back, to go back up a hill to Dave's house, or Dave's mom's house.
So both of the trails get to the same location?
Mm-hmm.
Okay. What kind of car do you drive?
I drive a Ford Explorer.
Okay. And Tabitha, on that night, September 9th, the day in question, she actually came down from that paved road, or drive.
Came from there?
Came from her camper, through, I guess, or down that paved drive.
Honestly, I would say I wouldn't remember. I don't remember which way she came from. I highly doubt she came from the way Dave came, though, so probably not. She probably came down the paved driveway.
Okay. Either way, those two driveways get to the same location.
Mm-hmm.
I have no further questions.
Thank you. Ms. Jipp, anything else?
I feel like we've gone down a rabbit hole, but I'm gonna ask you this. So if your car is parked here, what would be the fastest way in your mind to get to Dave and Tabitha's place?
To go on the side of my house.
Okay, to go on the side.
Yeah.
Now, if you're at this house and you're trying to get, where are your grandparents? Here?
My grandparents live where you pointed. Dave's mom and dad live, yep, in the back.
So if you're going to your grandparents, you're going this way or this way?
Yes,
Okay, and then if you're going back to there, you're gonna stay on the paved path instead of going around like that?
Correct.
That record can be very clear. I have no further questions.
Anything else?
No.
Thank you. Jury, any questions of her? I see one hand going up, a couple hands going up. We'll retrieve them. Take your time. I have a couple questions from the jury. If you know, where was Tabby's car parked in the horseshoe driveway before she backed up?
I don't know if you can see, but on the little island, there's a tree that sits on the left side, like maybe midsection. Yes. So her car was probably a little, maybe a couple feet behind that tree. Yes. Correct.
Okay. And where does Tabitha usually park her car?
Park in, like, where would she leave it if she was to be home for the day?
I don't know. Yes.
It would usually stay in the way back next to the camper.
Okay. And I'll ask Ms. Jipp if there's any way you're able to zoom in more in each of the driveways in question. That's it? Okay. As far as you know, Ms. Null, is this image accurate of the property, as far as you can tell?
Yes, very accurate, accurate, sorry.
Okay. Okay. And jury, that is an exhibit that will go, the copy, photocopy of that will be an exhibit that goes in to the jury room with you. Thank you. Counsel, any questions in light of those questions? Any questions?
In light of those questions?
Well, in light of, in response to the questions and answers we just addressed?
No, Your Honor.
Where is the camper in question? Where is Tabitha's camper located?
So there is I do believe that's,
Like here?
no. It would be more down if you were on the property. It would be directly where that patch in the way back is empty. No, that's Dave's parents' property. Warmer, down, over to the right more, right there, around in that area.
You're saying this is where Tabitha stays?
A little more over, it's on Dave's property.
So we're talking about over here?
No. It wouldn't be on Dave's.
I didn't actually look, that's okay. Oh gosh, this microphone again. So about
Right in this area is where the camper sits. The camper currently got moved to over here in this area because they were going to take it off the property.
And whose house is that? That's Dave's parents' house. Okay. Okay. So you able to hear that? Dave's parents' house? Okay.
Anything else, Ms. Mechek?
I don't believe so.
Okay, any other?
I did think of one additional question, if the court would.
Yeah,
let me
I'll
ask it. I asked you about whether or not you saw your mother throw rocks at Tabby's car. Did you ever witness your mother go approach Tabby's car or hit her car in the drive in front of your house?
I know my mom did get on the driver's side towards the window, but other than that, not that I can recall.
Okay, so she kind of hit in between the driver's side and the window.
No,
she got there?
arguing. I don't recall her hitting the vehicle, but a lot was going on at the time of everything, because she was out of breath, and at that point, I think Dave and Matt were still arguing, so she kept getting up and down, and everyone kept trying to tell her to stay down on the logs, but other than that, I don't recall.
Thank you.
Thank you. Any follow-up?
No.
Any other questions of her, jury? No, thank you. She excused from subpoena?
Yes.
Thank you. Any other rebuttal witnesses, Ms. Jill?
1 second, I'm
Okay.
strategizing.
Okay.
The people restaurant.
Okay. We have you at 7 exhibits, Ms. Jill, is that right?
Yes.
Okay, and I don't think defense, you didn't have any exhibits, correct?
Correct.
Okay. Okay, the parties have rested. I have one short matter to address with the lawyers, so I'll have you go back to the jury room. Should take less than 15 minutes, might be 7 or 8 minutes, depending on how this goes, but, and then when you come back, we'll do closing arguments, and I'll give you your final instructions. Remember, don't talk about the case with each other or anyone else yet. Jury, as I indicated, we are now at closing arguments. Ms. Jill?
You're going to hate to hear this, but I get a chance to talk, and then I get another chance to talk. So I'll try to move through the material quickly. We've all seen a lay of the land here, and we hopefully, by this point, day 2, have a pretty solid understanding of the key players here. The initial argument started over what Mr. and Mrs. Wilson and Tristan Null and Logan Null indicated, and I believe even Dave Beatty's testimony was over there being some sort of disagreement. He disagreed about any sort of reckless driving or issues there. But they all testified that essentially what started this whole kerfuffle is this reckless driving. And Tristan makes the choice to call Cody and Matt to the scene, hoping that that would de-escalate things, and that certainly, we can all acknowledge, backfired. Instead of de-escalating, tempers escalated, and it even sounds as though the victim in the assault at the hands of Tabitha Howard actually threw a punch at Mr. Beatty. He did not stick around to report that incident to law enforcement, so that was not investigated. After this argument dissipates, Tristan and Logan both indicated they stick around to make sure mom stops running her mouth and goes on home. And this old kind of, I have young kids, so this old kind of nursery rhyme keeps playing in my mind. Sticks and stones may break their bones, but words, or my bones, but words shall never hurt me. We could all clearly tell, based on Cody's demeanor here, that she likes to talk. And she, whether you consider her to just kind of railroad you or be strongly opinionated, she was genuine. She wasn't here to hide who she was. She testified she wished this had never happened. But she also testified she never would have expected this to happen, that it was a huge shock. So she's sitting at this wood, still maybe, jawing, maybe getting a little quip back from Tabitha. I believe Tristan testified that Tabitha was kind of throwing a couple explicatives her way. But all the parties think that this is a done deal. And Dave goes back around the 2-track drive to go home, according to Tristan's testimony, and I believe based on his own testimony he went back that way. Unfortunately, the defendant chose not to use that route, the route that she uses, to quote Tristan, 90% of the time. So instead, she backs out of the driveway. Instead of pulling forward and around, she backs out and chooses to go in the route that she knows she's going to inevitably run into Cody and Matt. Now, whether it's just a matter of you're going to get another earful or what the reasoning was, or she's trying to sell us now, I'm not quite sure. What makes the most sense based on the testimony of Cody and Matt is that she still had a bone to pick. Now, I know she took the stand and she's wearing a nice sweater and she cried and she was tearful, what typically I would celebrate in terms of demeanor of a victim. I would be happy to put someone like that on the stand. But I tell you, that was not the Tabitha Howard that was on scene on September 9th of 2022 when this all went down. So she gets back in the car, she still has a bone to pick, and she backs up and she goes down this driveway. Now, her story is that she sees Cody grab a handful of rocks and throw them at her car. You heard Cody testify that that is a paved drive. And then we saw pictures here where you see the edge of the road and dirt. I do not see a gravel driveway here. Did she maybe throw a handful of dirt at her vehicle? Maybe. Childish, but certainly nothing, that would have sent anyone to the hospital. So we then hear Matt testify that suddenly he hears a car come in and screech its brakes. He's walking about 15 feet ahead of Cody and turns around and sees at the moment that these parties are colliding, and he's, walking toward, I think the motioning that the defense attorney used, he kind of trots over to this argument where he then hears, she's hitting me with something. I don't know what exactly it sounded like because it'd be on soft flesh and bone, but he hears tink, 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 tink. And she's being hit in the face with a solid metal pipe. And you all can take this back to the jury room, and I encourage you to hold that and to feel that because it has quite a bit of heft to it. So he then tries to pull them apart. I think he initially indicates he goes like this, and he ends up grabbing a leg. And unfortunately, that positions Cody in such a way that she gets that last crack across her nose. And then he manages to pull Tabby's leg, the defendant's leg, and get her off. And instead of it all just ending then, Cody in a heat, rightfully so, she's been struck multiple times in the face and head, goes over and kicks her. It's easy for us to judge on the back end like, well, I wouldn't have kicked her. Well, no one knows how they would be in a situation until they're confronted with that exact situation. She kicked her. She took the stand. She acknowledged that she kicked her, and she apologized for that. And then Tabby gets up and comes after Matt with the pipe to the point where he has to simultaneously, I keep doing the wrong arm because I'm right-handed, but he has to simultaneously block and throw a punch to get her away. To understand this in a way that Tabitha wants us to believe it went down, it just doesn't make sense. The pieces of the puzzle, that circumstantial evidence, doesn't add up. There's no piles of rocks to select from. There was testimony that there is a security light, but that she had pulled up in front of it, so blocking the light, that you would maybe be able to, it only triggers, and then once you go past it, the light's not there. And it all happened very quickly. To say that she came, had rocks thrown at her vehicle, she stops her vehicle, she gets out of her vehicle, she claims she's confronted in such an aggressive manner that she had no choice but to grab whatever she could find and turn around and hit her. And yet, she describes Matt as Cody's weapon. So she's so fearful of them that she turns her back to them, opens her car door, puts a knee in on the seat, and reaches in and grabs something. Why the heck wouldn't you just slide yourself in there and drive off? Her window wasn't down. She testified that it had been cracked earlier, but she had rolled it up by the time she went on the drive. So it's not like they could have reached in and started wailing on her. She never testified she saw her having a gun. There's this peripheral, boneheaded issue of some
shots being fired into the ground. No one took the stand and said, yeah, Cody was shooting that gun. Cody said, I'm going to shoot you with this gun. I'm leaving with this gun. No one ever puts Cody or Matt with this gun once this altercation is ended. Now, Dave testified that from behind the Jeep, he heard shots and saw, and he just knew it was Matt. There's no other explanation for that. No one else seems to corroborate that. So she comes up onto the scene and she chooses to stop her car there. Why not go home and borrow somebody's cell phone and call the police and say she was throwing rocks at my car? Because there was no rocks being thrown at her car. Officers photographed the vehicle. There is no damage. There are no dents or pings from rocks. When asked that night, well, where did she hit the rock? I don't know. She was just throwing rocks. When asked who started the altercation, I don't really know. But today she made it clear that the victim was the first to swing. I guess however many months removed from September, maybe that memory just pops up and it's suddenly clear. Now you think, oh yeah, it was her. She came at me first. If someone is charging you in an aggressive manner and swinging first, they know they're in for a fight. So that if you're countering, you're probably going to try to block or do something defensive. There are no defensive wounds on the victim. What we see instead is she probably came over talking her little talk, running her little mouth about driving recklessly around her grandbabies, and she just got popped square in the face. Not even time to react, just boom, bam, right on the scalp. 7 staples. Stitches across her nose, needs follow-up surgery. This story only makes sense if Tabitha is the aggressor. She's sitting dazed, covered in blood, and says, Tabitha came at me. Cody's story hasn't changed since day one. Tabitha's story is, I don't know where I live. And you can explain that away by, Cody got a few good licks into. But, she doesn't know who that's running from her car. Well, I guess it's Dave because he's got a warrant. I'll admit that. No, I don't know who was swinging first. Tabitha has changed her story to suit Tabitha in hopes that you will buy this ridiculous self-defense claim. So I hope you go back and you deliberate and you look at these pictures and recognize that it is not possible to happen in the way that Tabitha Howard wants you to believe that it happened, and find her guilty of 2 counts of felonious assault. Assault with a deadly weapon. Same.
Thank you. Ms. Meacham?
Told you to buckle up, it was going to be a wild ride. I wasn't joking. What we know that a gun went off. Most certainly a gun went off. We know that Tabby hit Cody Wilson with an object. Happens to be a handle to a tire jack, which belongs in a vehicle. We're not denying that. But it's why. Why did it get to that point? You saw Cody on the stand. Volatile. Matthew, volatile. Tabitha, her demeanor, consistent, not volatile like those two. Imagine people like that going after you. Now, with self-defense, there's one very, very important aspect that I want everybody to keep in mind when deliberating. And that is, and as it relates to this rock, that Cody herself testified that had there been a rock, she would have thrown it. Oh yeah, she would have. Said that multiple times amongst everything else that she said. If Tabitha's belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Tabitha was scared. She had a volatile person who had backup, probably about 100 pounds more than her, a male, as the second person. 2 against 1. A female in that situation, alone at night, what would anybody do in that situation as a female? You got to put yourself in her shoes. What was she feeling that night? That's what's important. We can all talk, we can all say all these things, but really step into her shoes, put yourself into that situation at that time, and then deliberate. And I have no doubt that you will find her not guilty of count 2, the assault against Matt, who, let's all remember what happened there. He drug Tabitha by her leg or foot, whatever it was, and that gave the opportunity for Cody to then just kick her. Kick her while she was down. Tabitha gets up, dazed, rightfully so, and then someone's standing there, she gets clocked in the face by a man who is 100 pounds on her, right hook to the face, and she gets knocked out. Anybody would be confused about where they live at that point. That's not deniable. Matthew, he right hooked her to the face, and he said it himself. And for Cody to take advantage of the opportunity to just kick somebody while they're down, she could have went away, she could have walked away just as much. She was so afraid for her life because of her 15 grandkids, why didn't she? No, she stuck around and she continued her fighting activities and her behavior, her volatile behavior. Don't forget that. The situation, it happened. There's no getting around that. Would anybody do what happened? I can't say that I would do exactly that. However, I wasn't there to know. But what I can say is, if she was fearful as she was, she had to protect herself because she has a volatile person coming after her and she has the husband right behind. And who knows what could have happened if she did not protect herself. This is a self-defense case and she defended herself. Tabitha is not guilty of either of these counts and most certainly not against Matt. And I'm asking each and every one of you to return a verdict of not guilty. Not guilty of both count 1 and count 2. Thank you.
Thank you. Any rebuttal, Ms. Jill?
Just very briefly, we're going to talk jury instructions, which you'll be given and can take back and review and fight over and maybe ask us additional questions over. I do want to highlight another thing that I think is very important when you're considering the defense of self-defense. A person can use force and self-defense only where it's necessary to do so. If the defendant could have safely retreated but did not do so, you may consider that fact in deciding whether the defendant honestly or reasonably believed that she needed to use force in self-defense. I posit to you that this could have ended the moment that Dave drove off. She could have continued facing her car the same way, gone the same route she'd gone 90% of the time, followed her boyfriend safely home. But she wasn't done with the evening, so she chose to back up and initiate the altercation in the next driveway. It does not make sense the way Tabitha wants us to believe it happened. There were 2 individuals there that gave statements at the time. They've testified today. Those statements remain consistent. I hope you go back, you review any of the exhibits you need to kind of work through this and find her guilty of 2 counts of felonious assault.
Thank you. I'll now be providing you with the final instructions I'll be reading. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You must not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that's been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she's charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant's guilty. You've heard that a lawyer's representative talked to one of the witnesses, and there's nothing wrong with this. A lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, defendant is charged with assault with a dangerous weapon. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on Cody Wilson or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure Cody Wilson or to make Cody Wilson reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. Fourth, that the defendant committed the battery with a dangerous weapon. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they're specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as a dangerous weapon. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. If the defendant threatened to use an object or uses an object in a way that was likely to cause serious physical injury or death, it was a dangerous weapon. You must decide from all the facts and circumstances whether the prosecutor has proved that the metal pipe in question here was a dangerous weapon. Again, in count 2, defendant's charged with assault with a dangerous weapon. Again, to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on Matthew Wilson or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure Matthew Wilson or to make Matthew Wilson reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. Fourth, that the defendant committed the battery with a dangerous weapon. A dangerous weapon is any object that's used in a way that's likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they're specifically designed to be dangerous. Other objects are designed for peaceful purposes but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it's a dangerous weapon. If the defendant threatened to use an object or uses an object in a way that was likely to cause serious physical injury or death, it was a dangerous weapon. You must decide from all the facts and circumstances whether the prosecutors proved that the metal pipe in question here was a dangerous weapon. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about September 9, 2022 within Van Buren County. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. The defendant claims that she acted in lawful self-defense. A person has the right to use force to defend themselves under certain circumstances. If a person acts in lawful self-defense, their actions are justified and they are not guilty of assault with a dangerous weapon. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect themselves from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself, but you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. A person can use force in self-defense only where it is necessary to do so. If the defendant could have safely retreated but did not do so, you may consider that fact in deciding whether the defendant honestly and reasonably believed she needed to use force in self-defense. However, a person is never required to retreat under certain circumstances. A person does not need to retreat if attacked in their own home. They reasonably believe that an attacker is about to use a deadly weapon, or they are subjected to a sudden, fierce, and violent attack. Fourth, or further, a person is not required to retreat if they have not or are not engaged in the commission of a crime at the time the force is used, have a legal right to be where they are at the time, and have an honest and reasonable belief that the use of force is necessary to prevent the imminent unlawful use of force against themselves or another person. A person who is attacked by more than one person has the right to act in self-defense against all of them. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. The exhibits admitted will be available in the jury room for you to review. You've been given a written copy of the instructions you've just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. The defendant is charged with 2 counts of assault with a deadly weapon. Each count is a separate crime, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all of the evidence in the case. You may find the defendant guilty of both or either one of these crimes or not guilty. I have prepared a verdict form listing the possible verdicts. And count 1, you have an option of not guilty or guilty of assault with a dangerous weapon. And in count 2, again, option of not guilty or guilty of assault with a dangerous weapon. Counsel, any objection to my instructions? Okay, thank you. Okay, at this time, we're going to excuse one of you as an alternate juror, but you're still under my instructions not to talk about the case, even though you can go home now or wherever you want to go. You're still under my instructions not to discuss the case with anybody and all of my other instructions, and that's on the off chance that we had to call you back and start deliberations anew.
Julie Owens.
Thank you. We'll have you leave your notebook and the badge in the chair. Thank you. Okay, we'll have you stand while we swear in the bailiff. Well, you don't have to stand, but you're going to be leaving in a minute, so stand or sit, whatever you want.
You do solemnly swear or affirm that you will, to the utmost of your ability, keep the person sworn sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon.
Thank you. Okay, so now you can begin your deliberations.
I need the exhibits.
We're going to give you the exhibits, and you'll get a verdict form, and take your notebooks with you. Yeah.
Can we send this back a little, or just?
Sure, we can have that.